Friends, my name is Nizamuddin Ahmed Siddiqui and I am an Assistant Professor of Law at West Bengal National University of Juridical Sciences, Kolkata. I will be taking this unit on Doctrine of Basic Structure and Fundamental Rights on behalf of the content writer Pallavi Kota, Assistant Professor, Dr. B.R. Ambedkar Law College, Andhra University. This unit aims to fulfill certain learning objectives, which include: number 1, learning about the limitations on amending parts of the Constitution, understanding the formulation of the doctrine of basic structure by the Indian judiciary, understanding the doctrine of basic structure under Constitution and its relationship with fundamental rights under the Indian Constitution. With these objectives in mind, let us now begin the unit. The Constitution makers gave the power to amend the Constitution in the hands of the Parliament by making it neither too rigid nor too flexible, with the purpose that the Parliament will amend it so as to cope up with the changing needs and demands of we the people. Parliament, in exercise of its constituent power under Article 368 of the Indian Constitution, can amend any of the provisions, and this power empowers the Parliament to amend even Article 368 itself. The doctrine of basic structure is a judge-made doctrine to put a limitation on the amending powers of the Parliament so that the basic structure of the basic law of the land cannot be amended in the exercise of its constituent power under the Constitution. The question therefore arises whether there can be any limitation on the amending powers of the Parliament. If the answer to this question is not in affirmative, with the reason that the Constitution makers did not intend for such limitation, otherwise they would have provided for such in the text of the document, then another question arises: to what extent can the Parliament amend the basic law of the land? And if there will be no limitation on the amending power of the Parliament, are there not chances that this power of amendment in the name of constituent power can be abused? Friends, we will try to answer these questions throughout the unit. The Constitution is organic. What Edmund Burke has said about it is that a constitution is an ever-growing thing and is perpetually continuous as it embodies the spirit of the nation. It is enriched at present by the past influence, and it makes the future richer than the present. Part 20 of the Indian Constitution under Article 368 deals with the amendment of the Constitution. It provides for 3 kinds of amendments, that is, number 1, amendment by simple majority, number 2, amendment by special majority, and number 3, amendment by special majority and ratification by the states. The Constitution has to be amended at every interval of time as the need arises. A constitution which is a static constitution becomes a big hurdle in the path of the progress of the nation. As the time is not static and keeps on changing, in the same manner the political, economic and social conditions of the people also goes on changing, and therefore the provision of amendment in the Constitution has to be made with a view to overcome the difficulties of the phrase "we the people," which we may encounter in future in the working of the Constitution. If there were no provisions made for the amendment of the Constitution, people would have recourse to extra constitutional methods like revolution to change the same. The sense of national integrity and honor of India, the constitutional makers had before 65 years ago. What the sense of national integrity and honor of India, the constitution makers had before 65 years ago, the parliament is making every possible effort to keep itself to that objective. The doctrine has evolved in Keshavananda Bharati seeks to resolve a legal conundrum which arises in written constitutions out of the interplay between those provisions of the Constitution which guarantee the fundamental rights and those which enable the Parliament to amend the Constitution. The Supreme Court in Minerva Mills case observed that the Indian Constitution is founded on the bedrock of the balance between parts 3 and 4. To give absolute primacy to one over the other is to disturb the harmony of the document. This harmony and balance between fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. The rule of law and judicial review was also held as basic structure in Vaman Rao, Sampath Kumar and Sambamurthy cases. Effective access to justice is part of the basic structure, according to the ruling in Central Coal Fields case. In Quijota Holohan, the Supreme Court has declared democracy is a basic feature of the Constitution, and election conducted at regular prescribed intervals is essential to the democratic system envisaged in the Constitution. So is the need to protect and sustain the purity of the electoral process that may take within it the quality, efficiency and adequacy of the machinery for resolution of electoral disputes. In S.R. Bommai case, Sawant and Kuldeep judges have observed democracy and federalism are essential features of our Constitution and are part of its basic structure. In the same case, the Supreme Court has ruled that secularism is a basic or an essential feature of the Indian Constitution. In M. Nagaraj versus Union of India, the court observed that the amendment should not destroy constitutional identity, and it is the theory of basic structure only to judge the validity of constitutional amendment. The doctrine of equality is the essence of democracy, and accordingly it was held as a basic structure of the Constitution. In the judgment I.R. Coelho versus State of Tamil Nadu, Supreme Court applied this doctrine and observed that all amendments to the Constitution made on or after 24th April 1973, by which the 9th schedule is amended by inclusion of various laws therein, shall have to be tested on the touchstone of the basic or essential features of the Constitution as reflected in Articles 21, read with Articles 14 and 19 and the underlying principles. To put it differently, even though an act is put in the 9th schedule by a constitutional amendment, its provision would be open to attack on the ground that they destroy or damage the basic structure. If the fundamental right or other rights are taken away or abrogated. John Marshall, the American Chief Justice, on the life of the Constitution has said, a Constitution is framed for ages to come, but its course cannot always be tranquil. The amending power could not be exercised in such a manner as to destroy or emasculate the basic or essential features of the Constitution, including the sovereign, democratic and secular character of the polity, rule of law, independence of judiciary, fundamental rights of citizens, etc. As Justice Chandrachud has exquisitely laid down, that amend as you may even the solemn document which the founding fathers have committed to your care, for you know best the needs of your generation. But the Constitution is a precious heritage. Therefore, you cannot destroy its identity. There is no such exhaustive or exclusive definition of basic structure given by the judiciary. The judicial approach has been on case-to-case basis to define what basically is included in the doctrine of basic structure. Justice Mathew in Indira Gandhi case had stated, the concept of basic structure as a brooding omnipresence in the sky, apart from specific provisions of the Constitution, is too vague and indefinite to provide a yardstick for the validity of an ordinary law. Then what is the test of basic structure? The doctrine of basic structure is vague in the sense that there is no clear-cut list given by the judiciary, that such provisions of the Constitution form the basic structure. Rather, it has been left open before the judiciary to decide the same on the case-to-case basis. Though the first attempt was made to lay down the test of basic structure in the Minerva Mills case, H.M. Seervai, the celebrated constitutional law expert, lamented that a precise formulation of the basic features would be a task of greatest difficulty and would add to the uncertainty of the interpreting the scope of Article 368. In the case of M. Nagaraj versus Union of India, the court has tried to formulate a general test to decide if an amendment is against the basic structure of the Constitution. The court held that in the matter of application of the principle of basic structure, twin tests are to be satisfied, namely the width test and the test of identity. The court referred to the judgment in Keshavananda Bharati, which clarified that not an amendment of a particular article, but an amendment that adversely affects or destroys the wider principles of the Constitution, such as democracy, secularism, equality or republicanism, or one that changes the identity of the Constitution, is impermissible. In I.R. Coelho case, the court held, in respect of the amendments of the fundamental rights, not a change in the particular article, but the change in the essence of the right must be the test for the change in the identity. It was further held by the court that if the triangle of Article 21 read with Articles 14 and 19 is sought to be eliminated, not only the essence of right test, but also the rights test has to apply. The court also observed that rights test and the essence of right test both form part of the application of the doctrine of basic structure. Finally, the impact test can be used to determine whether any law destroys the basic structure. If the impact of such a law has an effect on any of the rights guaranteed under Part 3 of the Constitution, then by applying this test, the answer will be in affirmative, that such law is in violation of the basic structure. It is indeed true that the fundamental rights incorporated in Part 3, reflecting the foundational values or core basis of the basic structure principle, bear a special status in the whole scheme of the Constitution. This is evident from the clear and categorical provisions made in Article 13 and strategically supported by Article 32 of the Constitution. Various foundational values are made to reflect in fundamental rights enunciated in the Constitution. Once the Constitution has been framed, it is equally logical to state that those foundational values could be abstracted or derived from those fundamental rights. The judgment in I.R. Coelho holds exclusion of fundamental rights would result in nullification of the basic structure doctrine, the object of which is to protect the basic features of the Indian Constitution, as indicated by the synoptic view of the rights in Part 3. Friends, there is a differentiation between the values abstracted from fundamental rights and the fundamental rights from which those values have been abstracted. The abstracted values are of much wider ambit than the concrete sources. They have an overarching influence and cover situations that hitherto remained uncovered by the enunciated fundamental right. On the basis of this differentiation, it is possible to hold that a violation of a fundamental right in certain situations may not affect the foundational value derived from that very right in the larger social interest. Such differentiation is of immense functional importance. It makes our Constitution much more accommodative by broadening its base. The resonance of such a functional importance is found when the bench in I.R. Coelho case further observed that our Constitution will most certainly continue to be amended as India grows and changes. However, a democratic India will not grow out of the need for protecting the principles behind our fundamental rights. The second cognate issue dealt with by the 9-judge bench was the realization of the fundamental rights enumerated in Part 3 as constituting the very basis of the basic structure. The bench in I.R. Coelho, while adopting the principle from M. Nagaraj case, stated that a constitution, and in particular that of it which protects and which entrenches fundamental rights and freedoms to which all persons in the state are to be entitled, is to be given a generous and purposive construction. The generous and purposive construction of the Constitution, and particularly of fundamental rights, because of their special significance, essentially reflects the sociological approach to law, in which the core concern of the court is to realize the actual effect of the impugned law on the guaranteed fundamental rights. In this respect, the bench recalls the approach of the Apex Court in Sakal Papers Private Limited versus Union of India and others, wherein it was stated, while considering the nature and content of fundamental rights, the court must not be too astute to interpret the language in a literal sense so as to whittle them down. The court must interpret the Constitution in a manner which would enable the citizens to enjoy the rights guaranteed by it in the fullest measure. The shift from literal approach to liberal and purposive construction of the Constitution has enabled the apex court to realize the fundamentalness of the fundamental rights, and therefore discovering new dimensions of the protection of fundamental rights that were hitherto remained unexplored. Through their creative genius, the court reinterpreted, for instance, Article 21 that ordains no person shall be deprived of his life or personal liberty except according to the procedure established by law. Instead of a literal and narrow interpretation of Article 21 as adopted earlier in A.K. Gopalan versus State of Madras, the apex court in its landmark judgment in Maneka Gandhi versus Union of India has clearly and resolutely held that the procedure established by law should be in conformity with the principles of natural justice, and that law envisaged under this article should be informed by the test of reasonableness. Moreover, the expression life in this article does not merely mean physical or animal existence. The right to life includes right to live with human dignity. Likewise, the freedom of press, which though not separately and specifically guaranteed in Part 3 of the Constitution, nevertheless has been read as an integral part of the right to freedom of speech and expression under Article 19(1)(a). The right to vote and the right to know the antecedent of the election candidate have also been read within the ambit of Article 19(1)(a) as an essential attribute of the right to freedom of speech and expression. In this wise, the court has found that fundamental rights are deeply connected and that each right supports and strengthens the work of the other. The exploration of fundamentalness of fundamental rights has in turn helped in broadening the base of the basic structure doctrine by adding new features which are not so specifically mentioned in Part 3. This is done on the principle that certain unarticulated rights are implicit in the enumerated guarantees on the one hand, and settling the broader issues of justice and law in the light of the actual impairment of fundamental rights caused by the impugned law on the other. The fundamental rights thus make the basic structure doctrine perhaps the most significant constitutional control on government and legislature, and thereby a comprehensive guarantee against the access by state authorities. The independence of judiciary was also held to be a part of basic structure. For instance, in Vaman Rao versus Union of India, the Supreme Court held that all amendments to the Constitution which were made before April 24, 1973, the date on which the judgment of Keshavananda Bharati was delivered, including those by which the 9th schedule to the Constitution was amended from time to time, were valid and constitutional. In S.P. Sampath Kumar versus Union of India, the Supreme Court upheld the validity of Article 323A and the Act as the necessary changes suggested by the court were incorporated in the Administrative Tribunal Act. In a landmark judgment in L. Chandrakumar versus Union of India, a 7-member constitutional bench of the Supreme Court unanimously, while considering the Sampath Kumar's case, struck down Clause 2D of Article 323A and Clause 3D of Article 323B, which provided for the exclusion of the jurisdiction of the High Courts under Articles 226 and 227 and the Supreme Court under Article 32 of the Constitution as unconstitutional and invalid, as they damage the power of judicial review, which stands as the basic structure of the Constitution. The doctrine of basic structure has been subject to an intense debate in the constitutional arena with regards to its genesis. The notion or doctrine in constitutional sense can only be said constitutional when it has a constitutional genesis. This doctrine has anti-majoritarian flavor and is of prime importance as it prevents the Parliament from abusing its majoritarian power. It can also be criticized that it has extra-constitutional origin, as there is lack of basic in the basic structure, and what the Supreme Court has done is to assume to itself a power of veto on all constitutional amendments. But if such limitations on the amending power of the Parliament will not be there, then a day may come when it will be made a criminal offense to even criticize the government in power, and we may not be left with our basic inalienable rights, what the Constitution guarantees to us in Part 3. Criticizing this doctrine with the argument that the constituent power gets transferred from the elected representatives of the people to the judges of the Supreme Court, one should not forget the majoritarian power of which the Parliament is in possession of. The judiciary is the protector and final interpreter of the Constitution, and it is also below the Constitution. Friends, with this, we come to an end of this unit. I thank you all for listening to this lecture with patience.